Hi, I'm Leanne Newton. We're going to recap this week's drama with the Lively and Wayfarer case. Firstly, I apologise if there's any kind of background noise. It's school holiday and my house is chaotic and I can't get away from that. You can check out my threads on X. My username is curiae2001. I'm not a US attorney. I'm qualified in UK law. Everything I say is my personal opinion as someone who understands and interprets the law. It is not intended to be interpreted as legal advice. I would appreciate it if you could please like this video and subscribe to my channel. You can also press the notification bell to be alerted to future content. So this week we had a series of Amicus curiae briefs. James Vituscka filed his opposition to Sloane's motion to compel. Now, James Vituscka is the Daily Mail reporter. Brian Freedman responded to the Amicus briefs. We had some drama unfold as a result, and then false information was disseminated about me. So I'll be addressing that. And then finally, Stephanie Jones replied to both Abel and Wayfarer in her motion to dismiss. So let's start with what is an amicus curiae brief. The legal term amicus curiae is a Latin phrase that means friend of the court. The term refers to a legal brief, sometimes called an amicus brief. That may be filed with, it's usually in an appellate court, including the Supreme Court, and then these filings are made by parties who are not involved with the current case, but support one side or another on the legal issue at hand. To see it filed at district court level is incredibly unusual, but we did see them filed in support of Amber Heard in her Virginia court case against Johnny Depp. So, there is a lot of virtue signalling and statistics, which I'm not going to talk about. There was another filing by Elise Dorsey. I'm not covering that either. What I'm going to do is leave a link to Court Listener in the description, where you can access the documents for free if you want to read them in full for yourself. I'm only going to cover specific areas of this filing which are colour-coded, and I will be referring to this law as section 47.1, but in the filing it is referred to as Assembly Bill 933. I will start by saying that I understand what the law is trying to achieve. There is a genuine issue of retaliation towards people who speak out against sexual harassment, sexual discrimination, and sexual assault. That issue is very real. However, to try to shield an accuser from discovery, in my opinion, is completely the wrong approach. This protection only applies to complaints that are free from actual malice, and that is, in many cases, only going to be proven with discovery. My worry is if we start with a presumption of guilt or liability for male-on-female violence, we get on a slippery slope of setting that precedent for other types of allegations. The system is hard for women. I know this. I've been through it myself. It needs a balanced reform, not the removal of due process, which is the interpretation. This law, in the way that these organisations and non-parties are arguing for, it's neither equality or justice, in my opinion. So, in yellow, this is not a dig at the law or the suggestions that many people experience retaliation. But this is due to be the first time it's going to be interpreted by a court. And it's been 18 months since this Assembly bill was passed. And currently, no courts in the US have heard a case on it. This, for me, somewhat undermines the argument that it was desperately needed to correct an injustice that was as prevalent as is claimed earlier in the statement of this filing. In green, they're saying that one of the most significant burdens before Section 47.1 was a quote-unquote abusive discovery process. However, no court has seen this law before it. So it hardly seems that any lessening of this burden is due to Section 47.1. My views on discovery are simple. It is not enjoyable or pleasant, and there is probably an argument for a better reform in these types of cases. But it is an important part of the process to ensure fairness and justice. To be shielded from this process merely because of the specific type of allegation made leads to people potentially having to live their lives with false allegations over their head. This is not just about Justin Baldoni anymore. This could be any man or woman who could be falsely accused. And I don't believe that this was the intention of Section 47.1. The law only protects those who speak out about sexual harassment allegations in good faith or without actual malice. I made a post on X about 2 months ago before we were even aware of things like the Van Zandt lawsuit or the alleged attempted extortion of Taylor Swift. I feel like it really explained what is required for this protection to apply to Lively's claims and why I didn't and still don't think it will apply to her. I'll leave a link to this post in the description. It's well worth a read to understand this law. Another reason I see this as pointless is because this is supporting Lively's dismissal from Wayfarer's lawsuit against her to avoid what they refer to as an abusive discovery process. But Wayfarer is still a defendant in Lively's lawsuit against them, so she will have to go through discovery. And it's arguable that because she filed her lawsuit first, she effectively consented to going through the discovery process. She has not requested a stay of discovery on her. She has not attempted to argue this law should protect her from having to go through discovery. In blue, they suggest that Section 47.1 should be interpreted to prevent any cases that fail to plead actual malice to proceed. But Wayfarer have pleaded actual malice. In purple is a great footnote where Amicus concedes that there will be certain cases where discovery is required for cases that plead actual malice, which effectively moots their own arguments. In yellow, we have the "if all other arguments fail, you owe it to survivors everywhere" argument. This filing is laying the weight of American sexual harassment survivors on Judge Lyman by imploring him to look beyond the merits of Lively's case and consider the impact on everyone who may rely upon this law. Now, I find arguments like this nauseating, but I do understand why they're making them. I've already said that reforms are important and needed, but if we flip this argument on its head, what about all the people who want to see this properly interpreted with common sense, not a one-sided agenda, to see the correct balance of protections for sexual harassment survivors and the falsely accused? In orange, the filing is also arguing Reynolds and Sloan's defences on behalf of Lively. I'm amazed they stayed silent on her claims against Jed Wallace. In pink, and of course there it is, Taylor Swift had to be name-dropped. Her subpoena has been brought up without referencing that it has been withdrawn before this was filed. What I find disingenuous about this is that they conveniently omit the reason why Swift's subpoena was withdrawn, which, as we all know, is that it's widely reported to be because Swift allegedly provided Freedman with the information he was looking for. In green, to sum up, if the judge grants her motion to dismiss, he will be a saviour of sexual harassment survivors. However, if he denies her motion to dismiss, he will be condemning them for all eternity. I'm paraphrasing, but that's the dramatic tone at play here. In blue, there's a rather sneaky footnote which I don't like. The filer makes the argument that if Lively's case isn't dismissed, then not only will it have a chilling effect on survivors coming forward, but it will also have a chilling effect on the lawyers representing them and prevent them from zealously advocating for their clients, or, as they framed it, clients like Miss Lively. This argument disappoints me because having potential opposition backed into a corner with a guaranteed loss is not advocating zealously for your client. I hope that US lawyers who would be advocating for people who have been falsely accused will come out and state their case for the effect this law potentially has on them in zealously advocating for their clients like Mr. Baldoni. I am very uncomfortable with this level of gaslighting from lawyers. If they are good at their job, they should be able to advocate well enough for their client without Section 47.1, as it is being argued here. I will say that as an end of trial measure, the damages in Section 47.1 is not a bad law. My issue is the attempt to argue that it should be interpreted that the person arguing retaliation for speaking out should be dismissed before discovery. If they get to trial and it's proven that their sexual harassment complaint was made in good faith and that the person who they alleged harassed them brought a lawsuit in retaliation and the harasser loses that defamation lawsuit, then high costs and damages are an excellent idea. But this law should not be used to deter allegations from being proven or to stop falsely accused individuals from defending themselves. Just to wrap up about these Amicus curiae briefs, I just wanted to make one further point. Content creators who are not legally trained did quote the law wrong on the rules around these filings. To clarify, the Amicus curiae briefs are not months late. They did not have only 7 days to file from Lively's motion to dismiss. Here is Rule 29, and this is the rule that is being widely misquoted. I've marked the title in red where it states that these are appellate court rules. I've left subsections 1, 2, and 3 because they govern when and how an amicus brief may be filed. I've taken out subsections 4 and 5 because they are concerned with the contents, format, and the length of the briefs. And that is not what is relevant to what I'm talking about here. Subsection 6, which I've marked in red, is where the 7-day deadline comes into play. So I understand why people have read this and run with it, but that rule applies to appellate courts, not district courts, and this case is in the district court. Now, there are no rules for the district court because this is rarely seen at this level. Appellate court rules are not binding on district court rules. There is no time limit, and the judge can choose what to do. The judge can choose to do what he wants with these filings. He can refuse to accept them. He could accept them on the docket but not read them, or he could read them. We're unlikely to know whether he reads it or not unless he refers to them at some point. So we then had the response from Daily Mail reporter James Vituscka, filed in opposition to Sloane's motion to compel. I did say last week that she wrote a decent motion to compel, and the arguments between the two, how she presented them, were equally strong. I also said that I'd need to see his response and the subpoena to work out which I thought was the stronger argument. This week we saw Vituscka's response and I was very impressed. So in green, Vituscka sets out the 3 reasons why he is opposing the motion to compel from Sloane. 1. The information could and should be sought from the parties. 2. The information is unpublished news gathering. It's subject to reporter's privilege. And 3. The subpoena is overly broad. In yellow, Vituscka explains the scope of Sloane's subpoena and states it seeks all communications with any of the lively parties concerning the film, the lively Reynolds parties, the Sloane parties, Baldoni, the allegations in the above captioned matter, and or any press stories or social media related to the same. You can imagine how much information that is going to contain. In orange, Vituscka confirms that Sloane expressly reserved the right to move to compel seriatim on the remaining subpoena requests. In pink, Vituscka argues that the request can be and must be sought from the parties before burdening a non-party. This is a fair argument. Party subpoenas under Rule 34 should be used to seek information from the parties that the parties possess, rather than relying upon non-party subpoenas. In blue, we have a bit of spice. Vituscka details the reasons Sloane gave for seeking the information from him rather than compelling the subpoena they issued the Wayfarer parties. And simply, they don't trust Wayfarer and find them to be adversarial and unable to be considered a reliable source. Now, I will probably still be laughing at the irony of this statement from Sloane until after the trial next year. I can't believe she's even suggesting that after all the underhanded tactics we've seen from her, Jones, and the Lively's in this case so far. In the purple footnote, Vituscka alleges that Sloane commented that testimony from Wayfarer about what Vituscka meant by the statement would be speculative. I'd normally agree with this, but Vituscka helpfully points out that the subpoena is seeking documents and not testimony, so it's not relevant. In yellow, Vituscka asserts his reporter's privilege, which is protected by both state and federal law. He states that Sloane has not overcome this privilege because she has not attempted to show that she cannot obtain the information from another source. In purple, Vituscka hammers home a point I made in that just because Nathan and Sloane have disclosed their communications with him to the media for these lawsuits does not mean that Vituscka has waived his reporter's privilege. He points out that sources cannot waive a privilege that is personal to the journalist. In green, Vituscka provides an excerpt from the reporter's privilege to demonstrate how it applies specifically to all of his communications. I found this a bizarre claim that the privilege shouldn't apply to Vituscka just because he's a journalist, particularly as she tried to invoke the privilege for herself in her motion to dismiss despite not being a journalist. In orange, Vituscka claims that the subpoena is overly broad, and it is. It asks for all communications with any of the parties at any time and all communications regarding the film or the claims without any limitation. There is no world in which Sloane is getting all, if any, of that, as nearly all of it would undoubtedly be privileged. The request is ridiculously burdensome for a non-party too. Back to pink, Vituscka points out that Sloane hasn't even attempted to explain how the subpoena meets other requirements of the reporter's privilege to overcome it. In blue, Vituscka finishes strong by stating that even if there was some level of a partial waiver on his reporter's privilege, it would be very narrow, and he cites case law to affirm his position. This was a good, methodical response and a refreshing change from the virtue signalling or nitpicky bullshit that has been filed in recent weeks. I'm not sure if Sloane can now argue Vituscka, but I am looking forward to finding out. So then we had Freedman's response to the Amicus brief from the charities. So far he has also not responded to Elise Dorsey's filing. In pink, Freedman points out that the briefs were filed with Lively's consent, but don't serve any purpose other than to provide Lively with ammunition to launch inflammatory attacks on Wayfarer and use as a PR vehicle. In blue, Wayfarer points to Judge Lyman's practices, which state that amicus briefs are not permissible by letter. They also advise that they are responding by letter out of caution. Again in blue, on the next page, because I got excited, Wayfarer set out the circumstances under which amicus brief is normally allowed, when a party is not competently represented or is not represented at all. Obviously, Lively is represented, and it is fair to say that her lawyers are not incompetent. I don't agree with some of the things they do, but they're doing a competent job. Back to pink, Wayfarer cite case law which supports their argument that there is no right to file an amicus brief, where the only concern is how the court will interpret the law. In yellow, Wayfarer point out that the filing has not asserted that Lively's counsel are incompetent, and their sole reason for filing appears to be around their roles as drafters and champions of the law at issue. They argue that this would lead to inappropriate expert testimony at the pleading stage. And Wayfarer then argue that this should be considered an abuse and is not allowed. In green, Wayfarer points out that the organisations are not mutual friends for the court, as they align with many policy interests shared with Lively, including her affirmative action against Wayfarer. In orange, Wayfarer points out that this amicus brief raises issues that even Lively did not raise, such as the need to avoid abusive discovery processes in sexual harassment cases. They remind the court that Lively is already subject to discovery through her own claims against Wayfarer, an observation I also made, and that discovery is already well underway. Finally, in yellow, Wayfarer argues that Rule 29 should apply. To be very clear, Rule 29 applies to appellate courts, not district courts, as we talked about earlier. What Freedman is doing here is saying that the rule for appellate courts should apply. He is not saying it does apply. Freedman argues that 2 months after the motion to dismiss has been fully briefed is too long. But as there are no rules for these briefs in federal courts at this level, he suggests that the judge adopt the appellate court rules. Now, this is an argument I would make if I was in his position. It's a good idea. I don't know whether the judge will accept it. And to correct another inaccurate bit of information being put out, the appellate court rules do not trump district court rules. There are different rules for different courts. Freedman is making a case for an appellate rule to apply in this situation because there is no equivalent in district court rules. Otherwise, district court rule would apply. If appellate court rules trump district court rules, there wouldn't be a need for separate district rules in any circumstance, so the suggestion is wrong. This now segues onto a topic I originally had no plans to talk about, but things have unilaterally escalated and now I can't ignore it and let it go unchallenged. So I'm sure many of you follow Without a Crystal Ball. I did too, and I did enjoy her content, and I have no intention of being hateful towards Katie. But I am receiving abuse and hate from her, and she is making false statements about me, which I'm going to address now. So this is the post on Reddit where I corrected Katie on Rule 29. You can clearly see that I simply explained that there is no rule for the district court and that the rule she is citing is the appellate court rule. I also put a link for Rule 29 to show what I'm referring to, which is what you do. I don't just tell people they're wrong without evidence to support what I'm saying. Now, it's been claimed that my post was rude and yelling. But here it is, and it wasn't. There's no use of caps or exclamation marks. There's no abuse or name calling. More than that, I never intended to come across rude. I thought I was politely explaining the difference between the rules for the appeal court and the district court. It didn't go down well, but it also wasn't what it was later made out to be, which was this. Actually, this is Freedman's, and I just wanted to cover this. Now, Freedman's also confirms that there are no district court rules for amicus briefs, and he is asking the court to apply the rule. There's nothing here that's different to what I actually put in the previous post. But these posts were put up on Instagram about me. And you can see that the claims that she makes are that my post was yelling. You just saw for yourself that it was far from that. So I have a detailed thread about my interactions with her, which contain all the interactions I've ever had with her, because there haven't been many at all, literally a handful. And it also contains rebuttals to all the claims that she makes here, such as this one on the top left, where she says she's been nice to me. Now, my first ever interaction with Katie was to ask her why she had commented on more than half a dozen posts on Reddit telling people that I am not a credible commentator because I'm British. The moment of niceness came when she apologized. I was content with that. We seemed to be all good. I enjoyed her content, and there was no further issues. And here is her apology. Just so everyone can see that, she apologized. I graciously said, yeah, no, it's fine. We're all good. Thank you. And I didn't really say anything more to her until this point. But here's one of the messages between me asking her, why are you saying this about me? And us getting to the point of apology. This is my message. One of the things that Katie also put on her Instagram post was that I am masquerading as a US lawyer. And saying that I told her I was a US lawyer. So in this message, this is all one message. I've had to split it in two. And on the right-hand side here, I've underlined in red the bit where I make a point of saying I'm doing pretty well for a non-US lawyer. I make it abundantly clear I'm not a US lawyer. So, and on top of that, as I do with every video, as I did at the start of this video, I make a point of giving a disclaimer where I specifically let everyone know I am not a US attorney. Any video I have done where I am talking about the law, that's all the videos except the deep dives. There are 2 deep dives which are specifically about lawsuits. I put a disclaimer on them, but the other ones don't because I'm just talking about people. But any video that includes discussion of the law, I always put this disclaimer that I am not a US attorney and I've been very clear that I always defer to the knowledge of US attorneys. I just began commenting on law because when I studied law, I also studied international law as part of my modules. And, the law in both the US and the UK is written in English. And so I can read. And I can read the statutes. I read all the rules. I can read cases. And I can say, well, that's what this means. Or that's what the rules are for that. Because it's written in my language. And I know how to read these from my studies and my experience and my skills of UK law. Anyway, so now this is small and difficult to see, but this is a comment that, sorry, I'm just going to go back to the other slide. So yes, so this slide, as I said, the right hand side, it's underlined in red. I clearly say I'm not a US attorney. So for her to be writing posts where claiming that I have said to her that I'm a US attorney and I'm pretending to be one, that is not true. More than that, Katie knows it's not true. I have no intention of making an issue of this, but when anyone makes false allegations about me, I have the evidence to prove that they are false, I will do just that. During this trial, I've been commenting on the ability of Wayfarer's team to use Lively's words against her. Now, there has been a strong theme in this case of Lively and Reynolds' habit of telling on themselves. So when this drama with Katie unfolded the other day, I was sent an old screenshot from when she had an account on X, or it may have been Twitter at the time. I've been told that she was reposting a scathing post with a responding quote. The problem is the original post was from her own account, and I'm informed that she forgot to log out of her own account to log into a different account to respond and rant back at herself to give the impression that she was being attacked. Now again, allegedly. I do not know. This is what I was told when I was sent this. But one thing I did find interesting in this response at the top here is this line. You are a punk ass that is a bitch to creators. Now I'm just going to leave that there and let the words speak for themselves. I've got no issue with Katie. If she made contact with me, I'm quite happy to have a conversation and clear the air. I enjoy her content, but I'm not going to be made out to be that I was rude to her when I clearly wasn't. And I'm certainly not going to have my credentials falsely portrayed either. I can't just kind of let that go. Also, the following day, and I'm not saying this is linked to Katie at all, but the timing is interesting. But I'm going to cover one more thing, clarify it, and then put that to rest too. So the following day, after all that drama exploded, I woke up to a barrage of messages about a LinkedIn account that was purporting to be me. It had my name and a photo of me as the profile picture. Now, this is a photo that I'm pretty sure I have only ever uploaded to a Facebook account, which I deactivated some years ago. The photo is 8 years old, and it was taken within days of deciding to leave my abusive former marriage. The only other place this photo could have been accessed is on my phone storage and Google Drive. I've been very candid about my own experience with domestic abuse and how that was a big part of my personal reasons for following this case and wanting to see it ends with us succeed. In my video covering Jen Abel's amended complaint against Stephanie Jones, I shared how my former husband had been discovered to have put over 70 monitoring apps on my phone, which ranged from tracking my location to having full control remotely, as if he was holding the device in his hand. Also found in the police investigation was evidence of several accounts on websites which had been created using my details, all my photos, etc., but not by me. These websites ranged from normal sites such as Google Hangouts and chat forums, all the way to the other end of the spectrum to dating sites and porn sites. The ones that have been identified have been taken down. There was even a situation, just to give you an idea of how bad this got, there was even a situation where a car insurance policy was taken out, unbeknownst to me, on a car I did not own. The policy was cancelled by the insurer because the payment bounced, as the direct debit was not set up to my bank account. In the UK, if you have a car insurance policy cancelled by the insurer for any reason, it is nearly impossible to take out a policy with any insurer in your own name. We have what is called a motor insurers database, which shares this information. If I were to cancel a policy because I sold a car or something, that's fine. But if the insurer cancels a policy, that is treated as a red flag and shared on a communal insurers database. The effect of this was devastating for me, and even with the crime reference number of the police involvement, the insurer refused to remove this marker. I do not know for certain, but I am sure, in my mind, that this LinkedIn account was another account that stemmed from that period of my life. It has been circulated on and off for a few weeks now as evidence that I am not a lawyer. The education information in it was correct, except for the dates, which is another reason why I believe this may have originated from my former husband. The workplaces were not companies I had previously worked for. Also, the last entry in it, like the most recent place of employment, was several years ago, around the time I was finalising my divorce, around 2017, 2018. My ex was still very much harassing me and my family at that point. And the other reason I believe this could have been him is that the last entry, the most up-to-date employment, says that I work in healthcare. I do not, and never have. But my partner, my current one, works in healthcare, which again is something my ex would know. So that's the context. This account is not mine. It has also been removed as I reported it when I was first made aware of it a few weeks ago. I will also add, my photo being on it should not add any credibility to anything. To give you an example, accounts frequently use images that are not of themselves. Leave Heard Alone, for instance, has used a photo of Amber Heard as her profile image, but her account obviously does not belong to Amber Heard. Yet, these same people will argue that the use of my image is concrete proof that the account is mine, and it is not. As far as my credentials are concerned, my content took off suddenly and unexpectedly. I did not plan for any of this, and I have a young family I want to protect right now. I will turn my camera on one day and post my real name, but right now, I'm new to this and I'm still figuring out a lot. I intend to one day come out of the shadows when I'm ready, but it will not be by force. I could produce my registration number and prove what qualifications I possess, but the next argument will always be that I'm not a licensed US attorney, and that is true. It's also something I have vocally made a point of saying in my videos and on X. So the only reason people would need my registration number is to do things like file false complaints and cause problems for my personal life. So I'm not giving this information out publicly, nor should I need to. I explain the filings and give my opinion on them. I'm not giving that out just to appease some people and stop them from spreading information that they have been told is false. More so, if people continue to spread this false information, knowing that it likely originated as part of a domestic abuse situation that I endured, then that says a whole lot more about them than it does about me. Also, the fact that the person who was hounding me about this was alleged to be a lawyer themselves, who did not divulge any information for me to verify them, and was attacking me on a post written by another person who is also allegedly a lawyer, who also does not divulge any personal information to verify themselves. The irony and perception of double standards are not lost on me. And I do not take that to take a shot at either of them. One of them I like a lot and fully respect. But I think that people should be allowed to decide for themselves how much of themselves they share with the internet. Doing this is the first time I've even attempted to put myself back out there since what happened with my ex-husband. And I love doing it because I've met and collaborated with so many wonderful people, and the people who support me are just amazing and I appreciate them. So I'm not going anywhere. I've clarified this account. I spent 12 hours yesterday engaging with the person about this profile yesterday, and it was clear that there was never going to be any openness to accepting what I said. They don't have to. But, why not just say, well, if you don't show me your credentials, then, I'm never going to believe you. Why get into hours and hours and hours of back and forth, me sharing very personal information, for you to still sit there and say, well, I still don't believe you. It was clear that there was, it wasn't really a good faith that this place was coming from. I didn't even need to engage with them to begin with, but I'm always happy to answer questions that are asked with genuine intentions. So that is my stance on this profile. If you come across anyone trying to say it's mine, hopefully you can direct them to this video, because I'm not going to get into any further debates with anyone over it going forward. So now I've said my piece, back to the filings. We had Stephanie Jones file a response to Jen Abel's opposition to her motion to dismiss from Abel's amended counterclaim. There is little here that has not already been said in her motion to dismiss, so I'm not going to repeat myself. However, I wanted to contrast Jones's arguments in her motion to dismiss with her own complaints. Here she is arguing that Abel's complaint should be dismissed because Abel hasn't pointed to a single example of personal communication that Jones accessed. Now, leaving aside the fact that this information is likely to be ascertained in discovery, of which she is trying to block Wayfarer from obtaining in the case of the Edgeworth subpoena, Jones alleges in her own complaint that Abel stole company documents and clients. However, I haven't seen Jones point to a single Jones work document or client that Abel is alleged to have stolen in her own complaint yet, either. Jones also responded to Wayfarer's opposition to her motion to dismiss from their amended counterclaim. Again, it's vastly similar to her motion to dismiss filing, so I won't repeat all of that. The point of interest for me was this first paragraph, which seems like Ryan Reynolds' written performative spiel. Now, I'm not suggesting he wrote it, but she appears to have been taking inspiration from the Lively's opening statements in their filing. My personal view was that it's a professionally written word salad. And finally, last night I made my debut at live streaming. I was so nervous. I was really nervous. And there was a moment where Colonel Kurtz left me alone for 2 minutes and I didn't know what to say. But I love having good, wholesome conversations with people. So I am starting a new segment of my channel when I live stream with special guests. Last night I was deeply honoured to have my first guest. I have followed her since her early days, and I am grateful for all the love and support I'm now receiving from her in my own early days. And that was obviously Colonel Kurtz. We had an amazing chat about the Amicus briefs that have been filed and the arguments they are making. I'll leave a link to her channel so you can watch the video on my own channel, but huge thanks to Colonel Kurtz. I'm hoping to line up more chats with creators. I've reached out to Elsie. I've been on her channel before and she is such a good laugh to talk to. And I'm also going to be calling a favour from my honorary sister, citizen journalist. And yes, next time I will stick around to answer some questions about the case at the end. I was just so nervous last night, I didn't even think about doing that. So I'm really sorry about that if anyone did have questions, but I will definitely be doing it going forward. So lots to look forward to, plenty of stuff to leave behind me. Thank you for joining me, and I will be back again soon.